Welcome to this important video about discovering a secret or unexpected deportation order and what to do next. First, we will explain why this happens and how notice failures occur. Next, we will examine common administrative errors that complicate cases. Then, we will walk through the urgent steps to file a motion to reopen, followed by an evidence roadmap and practical prevention tips. Finally, we will test your knowledge with a couple of short quizzes and summarize the key takeaways. In this agenda, we will start with the discovery moment, then transition to the legal reasons behind in absentia orders, followed by administrative record errors. After that, we will move into concrete action steps for filing a motion to reopen, provide prevention strategies, and wrap up with quizzes and a concise summary. Before we begin, this content is general information and not legal advice. Immigration law is complex and fact-specific, and outcomes depend on the details of your case and jurisdiction. Consult a qualified immigration attorney for personalized guidance. If you are at risk of removal, seek legal counsel immediately. Now imagine discovering an old in absentia removal order that you never knew about. You never received any court notice, you never appeared, and there was no formal process you were aware of. Unfortunately, this is not rare and exposes due process problems in notice systems and record keeping. Here is why notice failures happen. The court sends hearing notices to the last address on file. If you moved and did not submit the EOIR 33 notice of change of address to EOIR, the court may consider you responsible for not receiving the notice. However, sometimes the system itself fails by recording a wrong address or failing to process a properly submitted change. In both scenarios, a defective or misdirected notice can lead to an in absentia order. Compounding the problem are administrative errors. You might see incorrect biographical information, such as wrong birthdates or misspellings. You may also encounter multiple A numbers associated with the same person, leading to confusion about which file is active. Additionally, missing records or long delays in FOIA responses make it difficult to verify your file history and understand what happened. To move forward, first confirm your case status through EOIR's systems. Next, gather robust proof of your address history, such as leases, utilities, USPS change of address confirmations, tax returns, and affidavits. Then, submit FOIA requests to EOIR and DHS components like USCIS, ICE, and CBP to obtain the address of record and notice history. After that, prepare a motion to reopen, arguing lack of notice, supported by a thorough declaration and exhibits. Consider requesting a stay of removal while the motion is pending, because a stay is not automatic. Additionally, if multiple A numbers exist, highlight them and request clarification or consolidation. Finally, monitor all deadlines and promptly answer any requests from the court or DHS. This table compares a motion to reopen based on lack of notice with other motions. For lack of notice, the law allows filing at any time because due process requires proper notice. The key showing is that the person did not receive proper notice, or the notice was defective. Evidence typically includes address history, USPS records, leases, affidavits, and FOIA documents. Other motions generally have a 90-day deadline, with some exceptions, like 180 days, for in absentia orders, based on exceptional circumstances. And they usually require new evidence that was not previously available. This mind map organizes the evidence needed to support a lack of notice motion. The address history node covers leases, utilities, tax returns, bank statements, and USPS change of address confirmations to prove where you lived and when. The USPS postal proof node includes forwarding confirmations, delivery tracking, or returned mail to show what happened to the notice. Government records are obtained through FOIA from EOIR, USCIS, ICE, and CBP, including case notes and the address of record. Identity consistency addresses A number consolidation and correct personal data. Affidavits include your declaration plus statements from household members, landlords, and employers to corroborate residences. Notice defects highlight errors like wrong addresses, missing hearing details, or mailing method issues. Finally, the timeline ties all evidence to clear dates of moving in and out. These are the essentials of a strong motion. Include a clear declaration detailing your moves, dates, and attempts to keep addresses updated. Attach exhibits, such as leases, utilities, USPS forwarding confirmations, FOIA results, identification documents, and any evidence of returned mail. State the legal basis. Lack of notice, requesting rescission of the in absentia order, and reopening of proceedings. For practical tips, paginate and label exhibits consistently. Use a chronology to tie moves to notice dates, flag multiple A numbers, and request consolidation. And consider requesting a stay of removal. This comparison distinguishes the EOIR 33 and AR 11. EOIR 33 is for the immigration court and must be filed and served on DHS counsel when your case is in court. Not filing can result in notices going to an outdated address, increasing the risk of an in absentia order. AR 11 is for USCIS matters and does not update the court's records. Therefore, if your case is in court, you may need to file both forms in their respective systems to ensure all agencies have the correct address. Quiz time. The question is, which form updates your address with the immigration court, also known as EOIR? Options are A, AR 11, B, EOIR 33, C, USPS change of address alone, or D, no form is needed. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B, EOIR 33. This is the form for updating your address with the immigration court. AR 11 updates USCIS records, but does not update EOIR's court records. Our second quiz asks, an in absentia order based on lack of notice can be challenged by a motion to reopen filed when. Options are A, within 30 days, B, within 90 days, C, within 180 days, or D, at any time. You may pause the video now to consider your answer. We will discuss it in the next section. The correct answer is D, at any time. When an in absentia order results from lack of proper notice, statutes allow filing a motion to reopen without a fixed deadline. Nevertheless, it is important to act promptly and consult an attorney. Key prevention strategies include performing regular FOIA checks across EOIR, USCIS, ICE, and CBP, filing EOIR 33 with the court whenever you move, and also using AR 11 for USCIS when appropriate. Maintain consistency across all official records, including A number, name, and birth date. Keep a personal timeline of addresses and maintain documentary proof. If you discover an order, act immediately. Gather evidence, file the motion, and consider requesting a stay of removal. Here is a practical evidence checklist. Gather leases, subleases, or landlord letters confirming move-in and move-out dates. Collect utility bills for the relevant period. Obtain USPS change of address confirmations and forwarding records. Include tax returns or W-2s linking you to the address at the time of the hearing notice. Add bank statements or pay stubs mailed to that address. Prepare affidavits from household members, neighbors, or employers. Use FOIA results to show the court's address of record and any notice logs. Include copies of returned mail or tracking data showing non-delivery. Finally, assemble identity consistency documents to ensure your A number, name, and date of birth are aligned across systems. To summarize, once you discover a secret in absentia order, confirm your case status right away. Next, collect comprehensive address and mailing evidence. Submit FOIA requests to EOIR and DHS components to uncover the government's address of record and notice history. Then, file a detailed motion to reopen based on lack of notice, requesting rescission of the in absentia order. Consider requesting a stay of removal while the motion is pending. Finally, prevent future issues by filing EOIR 33 and AR 11 when appropriate, and by maintaining consistent records. Thank you for watching. If this video helped you, please like, share, and subscribe. Comment below with your questions or experiences about notice issues and motions to reopen, and let us know what topics you want us to cover next.